Okay. Now let's share my screen. All right, everyone see the screen okay? That's okay. I'm gonna hide this guy here. Okay, so let's go back to when you got your real estate license, right? This was even before you took the state exam, right? And part of real estate principles was giving you the fundamentals and the basics of real estate, right? The trenches of which we're going to get into, right? And some of the fundamentals were fiduciary responsibility and what is your job description, right? Basically, your job is to help navigate, get the buyer and the seller into escrow, close the deal, navigate the transaction, negotiate, close the deal, and get paid a very good commission. But what we've seen in the past 15, 20, 30 years is that agents believe that they need to go above and beyond. And what I mean by above and beyond is giving legal advice, giving taxation advice, giving things as if they were an expert at a certain thing, contractor, right? Saying, hey, the roof, hey, the electrical, hey, the plumbing, hey, the foundation, right? And obviously, when looking at all the parameters of it, you'll see that the property, right, may look uneven, right? Well, we're not an expert on that. We're not in any position to give any type of legal advice when it comes to the property, when it comes to the legality, when it comes to the process. Our job as a real estate professional is to connect the buyer and the seller, promote the property, put it on the MLS, negotiate the deal, close the deal, and get paid a commission, right, Steve?
Yes.
Yeah. So, not to navigate and, start pretending you're an attorney, right? And sometimes we kind of go borderline with that, right? Because now we're kind of dictating what the contract says, right? And ultimately, with the California Association of Realtors and with the Department of Real Estate, and more so the laws of what a salesperson or a broker associate's responsibility, it's far and beyond that. Okay. Yes, there's technicalities to that. Yes, there's hurdles and challenges, and there's going to be problems. The purchase agreement defines everything. If you wanted to get the answer, okay, the answer to all of your questions, just look up the RPA, right? The RPA will tell you basically all of the answers, the do's, the don'ts, the buyer's responsibility, the seller's responsibility, the agent's responsibility, escrow, the lenders, and so on and so forth, even the property in itself. And if you really spend the time to educate yourself and learn some of the basic stuff of the RPA, you're going to be one step ahead of the game in more of knowing how to have that conversation with a very experienced agent that does 100 transactions, right? And even more so is that an agent that does so many deals sometimes doesn't know the initial heartbeat of the RPA. It really depends on someone that really studies, reads it, and really dives deep into it and has taken numerous of classes from the state level to the local level, and even in your office as well. So what today's topic is really the meats and potatoes of acting against the advice of the broker, all right? So let's dive deep into this conversation. And as we go, if you have any questions, by all means, please speak up. So this is pretty familiar, right, Steve?
Absolutely.
Fiduciary duties to the client. Duties of utmost care, integrity, honesty, and loyalty disclosure regarding the real estate agency relationship form, CAR Form AD. Now, the AD form automatically populates every time you do a listing. If you haven't done a listing, do a listing as a practice, and I can tell you that the agency disclosure will populate. When you do a buyer offer as well, the RPA, the purchase agreement, the agency disclosure will also populate, okay? Now, what's the purpose and what is the reason of having this agency disclosure, okay? I'm gonna throw a little wrench on there. Anyone have any thoughts why the agency disclosure is an important component to the purchase and also the listing agreement? This is a test. Anyone want to give it a jab at it?
Hey there.
Hi.
Sorry, I had to have my video off because of my external monitor, but hello from Shireen. What I tell clients is this outlines the nature of our relationship. It shows you what you can expect of me and also what I can expect of you. And it's about truth and honesty and fair dealing. And it establishes our relationship. And even, regardless of how the transaction ends, how many sides we have, this is establishing that I have the right to submit these documents that are underneath this on your behalf. Like, get technical. That's what I tell them. This is our relationship. This defines our relationship.
Yeah, okay. That's good. Anyone else? Steve?
Yeah.
I'm gonna pick on you, Steve,
I
because
had a feeling you would.
you are definitely right on with the same mindset that you and I have. So Steve, take it away, sir.
The agency relationship, like I tell my clients, is one that defines our roles. Okay?
Yes, I love that.
When I sign an agency relationship with the seller, it clearly defines that I represent them as the seller. And as such, I have duties and responsibilities to be able to represent their interests.
Right.
And that also then includes the responsibility of not to reveal any confidences that they share with me as well.
Right.
As an example, especially now, like in this marketplace that we are now in, where pricing is now critical, where sellers may want the house listed at X price, but they're going to tell you, but they have shared with you, well, I'm going to list it at X, but for the right buyer, for the right escrow period of time, I'm willing to come down below X by X dollars.
Right.
And the reality is, legally, we are not allowed to share what that number is to the public because that's technically confidential information.
Right.
Unless the seller gives you permission to be able to share that information with the public. Okay, that's just confidential information between the two of us. So the agency relationship spells out the duties and obligations of our roles. The same way then, when the buyer has their own agency relationship, they represent the buyer's interest.
Right.
Okay, so I'm not concerned about the seller. I'm representing the buyer. My loyalty is to be able to represent the seller or whichever client I'm representing. Okay, and I have the duties and responsibilities, with that of utmost loyalty and care.
100% love it. Yeah. Now I'm going to throw a wrench at you. What if you represent both parties?
Oh,
the old
agency.
dual agency, right? When you represent a seller and also represent the buyer as well. Yeah.
Okay. You have to use kit gloves. All right. Very much kit gloves, because if you end up having a dual representation, a dual agency, it is very easy to potentially fall into the trap to be able to, represent it, to be able to fail to represent each of your clients. Okay.
Right.
And so you have to end up telling each client at that point, first and foremost, that you are representing both sides. Okay. And that there are certain things that I can and cannot tell you. Sometimes then, as an example, if we are in negotiations, and at that point, each client had told you, the seller says, I'm willing to come down, the buyer says, I'm willing to come up, okay? You cannot tell each party to that.
Right.
You have to, unfortunately, I hate to use the word game, but you have to play the game of, I don't, you know, when the buyer says, would the seller be willing to take X? Even if you know the seller would, okay, the answer is I don't know, all right? If you want to put it in writing, we can end up seeing what the seller says. If it's not acceptable to the seller, I will encourage the seller to issue a counter offer.
Right.
Saying, and just the opposite, the buyer says, well, I'm offering this, but I'm willing to go up to this price.
Sure.
And if the seller asks, you know, is the buyer willing to come up? Well, I don't know.
Yeah.
Okay, and so, because again, you don't want to reveal the confidence that each had put into you.
So basically what you're telling me, Steve, is that if you know what the seller's bottom number is to sell the property, and the buyer is asking you, well, what is the seller willing to take? Can you divulge that information?
Yes, only if the seller gave you permission to devote that, and if they did, you better get it in writing
Yes.
that they gave you permission to do so.
Yeah.
Okay, if they did not give me permission to do so, the pat answer is I do not know.
I hope everyone heard that, but Steve is spot on that. Absolutely. You need to get written permission, even if it's verbal, right? It still will not hold water because it's hearsay. Yeah, we can say we had a conversation, but the seller can say, well, I don't remember having that conversation with you, Steve, right? I don't remember having that conversation with you, Simon. And that happens quite often. You know, we have so many things that are going on, the emotional roller coaster of a real estate transaction, right? You're not going to remember everything that was said. This is why it's crucial, folks. This is why having these documentations in place helps us to kind of remember, that's what happened. Oh, yes, I remember this now, okay? That's what helps us navigate the transaction. This is why you want to have a transaction coordinator, right? To hold you accountable to the transaction and the timelines to release contingencies and making sure that everyone is on the same page, right? Because there's a lot of moving parts when it comes to a transaction. You got escrow, you have inspections, you have an appraisal done, you have the lender and all the fun stuff that comes with it. And you're in the trenches of all this trying to navigate it because your job is to finish it, right? Your job is to get to the home stretch, close the deal, so the buyer buys, seller sells, and both agents that are involved, or if you're representing both buyer and seller, that you close the deal and everyone is happy, right? That's the whole purpose, right? So whenever you hear fiduciary duty, remember this, it is the utmost care and integrity to do the right thing all the time. And, you know, the agency definitely defines, because it'll say what the buyer's responsibility, what the seller's responsibility, what the agent's responsibility, and also what both, if you represent dual agency, also stipulates. So it's knowing and understanding your position. Yes, go ahead. Question.
Thank you. I wanted to comment, in law, you know, when we're discussing our fiduciary role, we have to say that we represent them to our peril, like even to our own peril. When we're fiduciaries, we actually have to put the client's interest immediately before ours. And, you know, in different lines of work, it goes up, you know, in different depths, but that's the phrase that they use, to our peril. They mean business, you know, these fiduciary papers.
100%. What happens if you're going in the trenches and you forgot to get this agency disclosure signed? And now you're the listing agent, you're doing everything, but you failed to get the agency disclosure signed by the seller. And then you find a ready, willing, and able buyer. And, you know, now this buyer backs out, but because the buyer and the seller are trying to work a deal without you, right? And you never really prepared an agency, or you failed to get a signature from the seller, right? And that will definitely either incur a procuring cost for a commission, And if you don't have that agency in place, what happens, Steve? They can challenge it and say, look, you know what, I don't remember ever signing an agency disclosure. So the relationship was never really established. Thank you. Established. So that's a position we do not want to be on, because that will definitely hold on water. And I've seen cases where I've been in court, and the first thing the judge will say is, did you have a agency disclosure? Yes. Okay. Did you have a purchase agreement? Yes. A listing agreement? Yes. Certain disclosures? Yes. All this will definitely anchor you to a better, stronger position of winning the case. Whereas if you don't have any of these disclosures or agency, it can definitely put you in a different category. And again, even my hands are tied with this if we don't have that agency in place. Okay. Good question. Thank you, Steve, for sharing. All right, well, let's go ahead and continue. So what do agents give advice on? Okay. All right, very elementary. All right, and I want to keep it elementary because I don't want you to go in the trenches. If you're not an attorney, if you're not a CPA, stop. Because if this deal goes sideways because you gave some legal or taxation advice, who do you think they're going to blame? Me, myself, and I. They're going to blame you. You're the one that got me in this mess. So now I'm going to go after you or your brokerage. Okay. So what do agents give advice on? Listing price, offering price, how to market the home, disclosures, contracts, and addendums, getting in and getting out of a contract, your name, some others. You name some others. My apologies. So that's really what it is. You know, marketing the property. You know, your job is to market, you know, to paint that pretty picture on why they should buy this property, right? But you don't need to go far and deep into this, because that's where agents eventually get in trouble. And now trying to backpedal out of a mess when you're deep in the hole can definitely hurt you. And that's what we're trying to avoid, is going in areas you shouldn't be going. If you don't know, don't guess on it, right? And how many times have we been in a position, and I'll be the first to admit, I remember doing this as a young agent involved in this, is like, I don't want to look bad. I don't want to look like I don't know what I'm talking about, right? And now we're in the cusp of this, and now you're trying to back out of a situation because you were not 100% sure of the issue or the problem, right? And that's where I see a lot of problems happening, and they're going to hold that against you. And once an attorney is brought into the picture, what is the attorney's number one job? Yeah, find the one that has the money, right? Who has the insurance, you know, and they know that real estate companies have insurance in place to protect the agents and the brokerages. So attorneys already know that, just like most high-end vehicle, right? If you see a nice high-end vehicle, most likely they're going to have insurance to cover that. Whereas a beat up vehicle, right, that's probably 20, 30 years, they may have no insurance or very limited insurance, right? So when they see big real estate companies like a Keller Williams, they believe that these brokerages have deep pockets, and they know that we have insurance to protect you from, you know, claims and issues and lawsuits and all that fun stuff. And no real estate company wants to ever be involved in any type of mediation or arbitration, right? That's just time wasted, energy wasted, and, you know, the emotional aspect of your business too, because now you're in the trenches of dealing with something, spending hours and hours and hours. I remember my last mediation, I was out in the West Los Angeles area. Beautiful building. I was probably at the 12th floor, and I was there at 9 o'clock under a mediation. It was my agent, my agent's client, and then the opposing agent and the opposing agent's client, our attorney, their attorney. And when you walk into a mediation, especially a high-end mediation company, it's pretty. It's like a 5-star resort. You walk in, beautiful. You got all this beautiful views of the canyons, and more so, they entice you. You see food everywhere, snacks everywhere, water, soda. They have all that because they know you're going to be there for a long time. And if there's no meeting of the mind and no agreement, they can take hours, literally hours. You go in the morning and you're still there till 7 in the afternoon, back and forth, because we cannot come to an agreement. Now, mediation companies and mediators that, do these love it because the more they're back and forth, the more money they make, right? You want to try to get that. That's why we tried as brokers, try to navigate that before it escalates to a mediation, before it escalates to an arbitration, or even before it escalates to even an attorney involved. And now they're sending a demand letter, right? Now it's like we have to respond, we got to stop, we got to get risk management involved, get their attorneys. They're the first line of defense before we even call insurance. We want to protect our insurance because in insurance, E&O, it's no difference than, protecting yourself from an automobile accident, right? If it's your fault, not your fault, sometimes the premium will go up, right? Well, insurance is the same way. The less claims you have against the brokerage, the better. We always cross our fingers every single year when we have to renew because they want all the documentations. They want to know how many sales, what was the volume, what was the commissions, what are we selling? Is it commercial, residential, manufactured homes, raw land, mobile homes, business opportunities, you name it. They want all this. They want to see the trade lines of activity that a specific company does to determine what their next insurance premium is going to be. And if we have no claims that year, congratulations, because that means that our premium is not going to go up. But if we have a claim or two, then it puts us in a ding. It puts us in a bad negative because now the current insurance adjuster may not want to insure us. And now we're looking for another brokerage. And now they're going to see, well, this company has a big liability. They're going to want more money. And I've seen in the thousands and thousands of dollars. And then just the deductible can also be pretty crazy. So this is why being a very proactive company definitely helps to minimize. Having a second layer, which is our risk management team, to help your clients navigate, squash it, will definitely help the situation. Steve, would you agree to that?
100%.
Yeah.
100%. I mean, it's one that, everything goes to the level of communication to your client. Okay. And so obviously, when you know issues are arising, and especially then if it's an arena that you have no knowledge about, immediately you need to be referring your clients to the appropriate arena, whether it be from the legal standpoint or the trades issue, at that point.
Sure.
But everything, I think where a lot of agents truly get into trouble in this regard is they give advice in an arena that they truly have no knowledge on. And
Sure.
the client relies on that ill-given advice.
Right.
And it takes a situation from bad to worse.
Worse.
Okay.
Yeah.
As opposed to if the advice would have been, you need to seek out the appropriate professional rather than you giving them what you think is the appropriate advice. That unless you know with absolute certainty, okay, the advice that you have to give is you need to go seek it out by the appropriate professional.
Love that. Absolutely. 100%. Thank you. Yeah. Take my advice, please. Do clients ever ignore your suggestions? What do? Should you document for your file what you said, when you said it, and to whom you said it to, for big issues that could have a legal consequences, and send written to clients? So really the nutshell of this is, the importance of following the rules and regulations, right? The policies. And when was the last time you actually looked at your policy and procedures manual, right? When you joined Keller Williams or any brokerage, right? The onboarding packet is also your policies and procedures. And once you sign that, you're basically acknowledging that you saw it, you understand what you were signing, and then that's benchmark that you will follow those rules.
So we're signing the same way our clients are signing our.
Yeah, exactly, right. Sometimes clients just initial, signature, right? Without even knowing, right? And more so, guys and ladies, I'm sorry. DocuSign. Okay. It's a great platform, but it also is a fine line, in my opinion. All brokers kind of, see what I feel, right? And Steve, you probably know what I'm going with this. With DocuSign is, I love DocuSign, don't get me wrong. It streamlines a lot of our paperwork, right? Where 15 years ago, we didn't have that platform. We had to wet signature, right? Well, DocuSign has revolutionized our position and given us that perspective now where we don't have to, have a wet signature, which is a good thing. But it also can be a bad thing, right? Because anyone can claim is, Simon, right? And I just need to have an email. It doesn't have to be your email, just an email that this DocuSign would go. Now, how many of us have multiple emails? Okay. So there you go. I mean, how can you really, truly authenticate someone's signature, right? That's the problem, and DocuSign will back it up, and they've probably been in litigations regarding. And ultimately, California Association of Realtors has adapted DocuSign. We have it in our command platform here at Keller Williams. So it has its pros and cons. It has its benefits, right? It helps us get paperwork done efficiently. Boom, get it signed. Boom, get it to the right people. But on that same token, who is the person behind the scene really signing, right? And they can say, well, yeah, that's my signature, but I don't remember signing that, right? And that can happen. So, I really want you to kind of look at the big picture when it comes to this, because it can definitely go sideways as well. Very far and few, but it can happen. What issues warrant written and sending clients a letter? So let's talk and dive deep. And the beauty is that the California Association of Realtors, your ZIP forms, has not just your contracts, your purchase agreements, your disclosures, or listing agreements, your addendums, your request of repairs, your withdrawal of offer, your lease agreements, your vacant land agreements, all the beautiful 300 different forms we have, right? But the broker office manager gives examples, right? So buyer moving in early, right? Seller staying after close without a written agreement. Seller refuses to make an agreed upon repairs. Buyer removing contingency without getting the seller disclosures. Broker office manager asks for examples from agents. How many of this can truly happen, right? There's a form for each of these different types of scenarios. Let's say that the buyer wants to start moving stuff into the house. They don't own the property. They're still in escrow. But now, they're being pressured from their current place to vacate and they have nowhere else to go. And they're asking the listing agent and they're asking the agents, to kind of work something out where the buyer can start moving stuff into the residence, right? A house that they still don't know. And there's still no guarantee that that deal is going to close. And I'm going to give you a scenario that truly happened. Now, 10, 15 years ago, we didn't have this document, but now we have a document to back it up. That document allows the buyer the opportunity to do that, where they do not own the property. Now, in my opinion, and this is just my opinion, every manager, every broker may think differently, right? But I still believe if you don't know it, if you don't own it, you shouldn't start having your personal items there. There's so many things that can happen, right, Steve?
Absolutely.
Theft, damage, fire, right? Certain areas of the US, right? Look at the hurricanes in Florida, right? Imagine, your clients were putting stuff, they moved from California not knowing, the condition out there in Florida, and then you get this hurricane, and now the water is up here, right? And a lot of your stuff is in the garage, right? So there's many things that can happen, but there is a form that says that Mr. and Mrs. Buyer, be aware, yes, you could, as long as the seller agrees to, because it's not between it's not between the agents, it's between the principals involved in this. But if the seller says you're perfectly fine, they don't live in the property anymore, it's vacant, there is a form for that allows the buyer to start moving certain things. And obviously there is some conditions regarding that. But there is a form. As long as you sign it, you document it, and you have it. And now, you're basically opposing what the broker, because me, if I was the broker in this particular scenario, I would say, you only have 5 more days, to close on deals. I would feel much, much, much better if the deal funds and records, and then, the buyer moves in to the property. But that's me. But I can't force, right? I can't force. Steve, can you force your buyers or sellers to do what you say? Yeah.
Understand, many times when you're the listing agent, being the recipient of the request from the buyer's agent, and you go, I will then ask my seller about that.
Right.
Typically, the seller's response to you before they give an answer is what's the downside if I were to do that? Okay. And this is where you have to be somewhat careful.
Yeah.
Give the answer, typically, well, there could be some potential, okay, that, if the items got damaged or theft and all that, potentially, there could be some, potential legal litigation from the buyer against you in so doing.
Right.
Theoretically, also, there could also be, liability, in case someone got hurt, even in the quest of putting those items into the property.
Right.
If they tripped and fell and the whole bit. And then, so there are downsides. And so at that point, I said, I would also, if you are considering it, you may want to consider consulting an attorney, at that point for their blessing and or any other considerations.
Right.
But I can't give you, the green light saying that it would be without any problems.
Absolutely.
And so typically, I advise my clients against it just to avoid those potential
Absolutely.
headaches that we don't need.
Absolutely. Yeah, spot on. Thank you. Yeah, I feel the same way. If we can hold on until it closes, even better, peace of mind, because you just never know. True story. This was before I was the broker. I was taking over. I had this file, and this file was from my previous predecessor as the broker. And apparently what ended up happening is that the seller allowed the buyer to start moving stuff into the property. And they were in the trenches. Everything looked fine until the lender stopped. And something came up on the buyer where they couldn't qualify for the loan. And they had already literally 90% of all the items already moved. They had already given their notice from their apartment unit So they were like literally in the property without confirmation. We ended up canceling. And when I got this, it's like, holy moly. This just did not happen, right? You can think that just because the buyer has released all contingencies, you know, doesn't 100% mean that it's an assured thing. And that's exactly what happened. The buyer thought everything's fine. They ran a second credit check. They ran their credit, and a child support, whatchamacallit, what do you call it? Jeez, it was top of my head. Lien, a child support lien of 125,000 came up. So that just threw a wrench. And that needed to be taken care of. They were not going to allow the loan to go through because the underwriter stopped it. And now the buyer was like, what the heck? So ultimately, you know, there was no choice. They were going to transition. Thank goodness that the seller was not in real need of the proceeds of that house. It was just one of those very unique situations that, you know, the seller was okay, you know, kind of going through the trenches and letting the buyer stay as a tenant. And they ended up staying as a tenant for 8 months. 8 months, and that gave them enough time to ultimately work with the government on that child support. Apparently there was an error, but it was an error that he was going back and forth with the county, and that was not the amount, and ultimately he was able to get it done, but 8 months later. And now he started, then he started now with the position of reapplying for a loan. And then 30 days from then is when he finally closed, but he was a tenant. This was a buyer who was buying this property, stopped because he had a child support lien. And the good thing is, I mean, this was a good scenario that the seller was not in any urgency to get the proceeds. What if this seller needed the funds to buy another property, and now you have a tenant in there? That would have thrown off, there would have been a crazy lawsuit. I mean, so many variables, so many issues could have just happened. And I was involved in this, and I was like, oh my goodness, you know, this is crazy. This is bananas.
Or worse yet, that I've heard
Yeah.
early possession. And they're thinking everything was going to be hunky-dory.
Yeah.
They get in and they start tearing the place apart for the remodeling.
Right.
And in the middle of the demo, they find out that they can't qualify. Like they
Yikes.
thought they did.
Yeah.
So now the seller is now stuck from the nice home they had, or
Right.
the demolished home they had.
Right.
Now a demolished home to a buyer that cannot perform.
Yeah.
And if you don't think that isn't going to be a headache, okay,
Yeah.
if you were involved with that.
Wow. Yeah, that's some serious stuff there.
Yeah. Absolutely.
So, and that goes with contingency removals too, right? You know, we don't dictate when the buyer should release contingencies. And when I talk about contingencies, I'm talking about, you know, physical inspections, seller disclosures, HOA disclosures, appraisal, and loan contingency, right? Because the contract already stipulates that the buyer is responsible to release this, not the other way around. Now, the listing agent, and it's really the listing agent forcing and putting that pressure on the buyer to release it. But what it says is that the buyer is the one that initiates that release. The buyer is the one that's supposed to release that contingency. Now, and I've been in scenarios, and Steve, you probably been or have heard, you know, when the buyer releases any and all contingencies, and now they don't qualify, or they were premature, right? Because they really wanted the property, they put their feet 1 foot in, thinking it's going to be okay, and they release from the very beginning all of their contingencies. Now they're exposing their deposit. And then later we find out that they cannot afford, or cannot qualify for the loan.
And this is where, matter of fact, this is where our job as an agent comes in with our fiduciary relationship.
Absolutely.
To our client.
Right.
Matter of fact, in this crazy market we just came out of with, you know, the 20 offers on the home, and, you know, our buyers would say to us as agents, price aside, okay, what else can we do within our offer to make our offers more attractive?
Right.
Should I remove the loan contingency? Should I add the appraisal contingency, the investigation contingency?
Right.
And if you as an agent answer yes, all right, you are absolutely exposing yourself to your client in so doing. So for instance, then, removal of the appraisal contingency.
Right.
Anytime an agent were to say yes to that, they better have made sure they understood what that means by removing an appraisal contingency in comparison to the price that the buyer was going to be paying in relation to the potential of where the appraised price may come in at, and what that would mean to their clients.
Right.
And, of what financial obligations that means. And if the agent then agreed without explaining anything to them, they are in violation of their fiduciary agreement to their client. Okay.
Right.
Same thing as an example with disclosures.
Right.
All right. Been able to have your buyer sign off on all contingencies and you haven't received seller disclosures. All right. At that point, it's like, the reality is you need to be able to have your buyer be able to review disclosures. All right. And when you're a listing agent, speaking of disclosures, you need to understand of all the disclosures, the TDS disclosure is the #1 disclosure that needs to be given to the buyer. Because even after the buyer has signed off on all contingencies,
Right.
if they have not been given the TDS, they have 3 days, buyers have 3 days to be able to back out after receipt of non-approval.
Absolutely, 100%. And you don't want to be in that position, right, where the buyer has that authority to review and then make a decision. After really looking at these additional disclosures, I think we're going to back out. It's like, holy moly, right? Who's at fault there, right? Who's going to point the finger? It's probably the seller against you. So you got to be very, very careful. All right, so let's continue. Thank you, Steve, for sharing. What issues only warrant a note to the file? Broker office managers give examples: paint, stage, removal, clutter, talk in private, not at an open house, price to list, price to offer. Broker office manager asks for examples. How to send client letters. So the beauty is that the California Association of Realtors, with the member benefits that you have through ZIP forms, it provides you with the necessary forms, but it also provides you with additional library of letters that were drafted by the legal team at CAR. So the brokerage company forms on CAR forms is open ZIP forms, go to the CAR sample letter library, and then there's where you have your drop-down menu, finding and acting against the broker's advice. So the forms can be illustrated in the both the buyer and also the seller. So finding, acting against the broker's advice for buyers and acting against the broker's advice for the seller. Depending on who you represent, if someone is going beyond the scope and going against the broker's advice, right? That means if you represent the seller, then they are going in a different direction. Then you want to prepare this letter and give the letter so that way, if it goes sideways, they cannot come back to you and say, well, Simon, you told me. No. I've explained, and you have the written document that I told you that it's opposing what the company is allowing. And when we say against the broker's advice, it's not necessarily the, Simon, the broker, but the brokerage and the policies and procedures. And, the California Association of Realtors, work really hard to, prepare these documents, and they know exactly the purpose and the reason, because of issues, because of litigations, because of lawsuits. So here's what it looks like. So when you go on your ZIP forms, you're going to click up here. I know it's kind of hard, but you click here, and then that'll take you right into the CAR sample letters. And then that's where you'll see all of the fun stuff, such as your California Association of Realtors, your America Home Shields, your finance, helpline library, your foreclosures, prevented library, NARS, and, if you're part of San Diego, but that's where you go for the California sample letters. The car sample letters is right there. Then once you go into the drop down menu, then that's where you'll see all of these different types of letters that you can utilize for that purpose, right? If it's a demand seller to perform, if it's a buyer to perform, there's all kinds of different letters, such as, demand to seller to close, demand to compensate after close of escrow, right? You haven't got paid in a commission. It's like, Simon, we closed on this lease, but I haven't received a commission out of it. I've been trying to reach out to the agent, and he or she is going MIA on me. Can you help? Yeah, well, let's go into the zip forms. Let's prepare, and we'll send it over via email as confirmation, and then I will follow up. If we still don't get any callbacks or a check, then I will definitely escalate it to that brokerage, speak with the manager or broker, and see if we can navigate this and get you paid. So again, the forms are there for your benefit. These are pre-printed examples. Make offers with no or limited contingencies. Okay, again, as Steve was saying earlier, a year ago, that was the norm, right? Is to go in there basically exposing the buyer, meaning you go in there with zero contingencies, you're signing off your life. And the buyer, has a deposit. If the buyer decides to back out at any given time after releasing all contingency, folks, seller may be entitled to a breach of a buyer for breaking the contract. And
or worse yet, what was happening is the buyers who went in with no contingencies, which meant no investigations. Buyer closes the escrow,
right,
moves in 30 days later, realizes there is foundation issues.
right,
okay, that will not cost them hundreds of thousands of dollars in repair.
right.
And it's like, what do I do now, Mr. Broker? Okay,
Yeah.
you told me to sign off on the investigation. Okay, you said, in order to get this house, remove your loan contingency,
Right.
remove your investigation contingency. So I listened to you, and I did it. I got the property, but now I'm stuck with, I wouldn't have bought the house had I had an inspection, but you told me not to have it. If that was the only way I was able to get this property in a highly competitive market.
Right. Now, Steve is not reflecting on me. I would never say that. I just want to clear that, that I would never say, please release all your contingents. That's the only way you're going to win. But in all honesty, at the end of the day, it's really the buyer's discretion. If the buyer is willing to risk, and that's the key, willing to risk, then it's perfectly fine, because now the buyer is in the known. He knows, she knows, they know that if they don't perform, they don't close, their deposit may be in jeopardy. Now, some of the avenues and how you can navigate this is don't go all in with the deposit, right? Fish and see if you can put a very small deposit that the buyer is okay to lose, right? Because we're always programmed in our minds, right? 3% of the purchase price, 3%, right? What if you go and make an offer, zero contingencies, but throw $5,000, right? Or $10,000 that the buyer is willing to, risk. And if the seller agrees to it, then, at least, if this deal goes sideways, the buyer is going to be okay. Now, we want to protect the buyer's best interest, right? We want to protect, especially if you represent the buyer in this, you're going to navigate, you're going to try to come to some type of negotiation, because remember, at the end of the day, and I know Steve will back me up on this, is that even though the buyer has released all contingencies and exposing $30,000, it's not till mutually agreed upon by both parties. So just because the seller has breached, just because the buyer has breached the contract doesn't necessarily mean that the seller can go into the cookie jar and say, well, this is mine now. No, it doesn't work that way. This is why we have a third-party neutral company, such as an escrow, that will navigate this. And that's when mutual, it has to be agreed, even though the buyer has breached. the buyer has to sign off on it saying, okay, release the money to the seller. I was at default on this, and I knew what I was getting myself. I couldn't perform. I'm not going to tie it up. Go ahead and release it. Or you try to negotiate. And again, it depends. If you go to mediation, there's going to be cost, time, and energy. If it escalates to an arbitration, time, money, and frustration sometimes. Of taking time off to go and spend hours and hours trying to dispute the deposit. But some sellers will. I mean, right now I can tell you there's one that is a $100,000 deposit. Buyer has released all contingency, and right now they've escalated to a mediation, and they still cannot get in meetings of the mind. So now it's going to escalate to an arbitration. And once it goes to an arbitration, it's no difference than a court hearing. They're gonna hear both sides of the story, and you're going to be able to cross-examine each other, bring character witnesses, and then ultimately the arbitrator is going to hear the case and come to a conclusion. And if the conclusion sides to either party, then that's it. That's all you need to take to escrow. Here it is. We won the case, release. We don't have to get the buyer's okay, because we have the arbitration hearing saying that the seller is in the wins of this. So again, the pros and cons of these situations. Removal of contingency early or without required disclosures from the seller, failing to investigate the property, very common things, right? Closing escrow without receiving reports or disclosures. How many times have we been in those situations where late disclosures are coming? Well, if you haven't received any of disclosure, you got to be proactive. Start calling the listing agent. Hey, I haven't received any of the disclosures, city reports, stuff of that nature. You want to stop from closing, because once it closes, it's hard. The seller is going to say, I'm done. I moved out already to the Bahamas. Okay. It's going to be very hard to really find that seller. So you want to nip it immediately. Do not close. Extend escrow if you need to. Bring us into this involvement. Let me know, let your broker know, and get your team leaders involved, because again, our job is to help navigate it before it escalates into a claim. Hope that all makes sense. And again, I'm not trying to scare anyone, but I'm just giving you life scenarios to be proactive. Steve says, we kind of do want to scare. I wish I had more people jump on these calls. Maybe I need to change it up. I don't know. I mean, I appreciate all of you, and I see the committed people that are constantly on here, but we definitely need to get more and more people on these calls. I mean, these 30 to 45 hour sessions can be, something that, not all of it is relevant. Maybe just something that you pick up and realize, I remember when Steve was saying, when Simon was talking about this, can be relevant and help you avoid a potential claim. So here's a sample of a letter that you can use, which is used as acting against the advice of the broker. I'm not going to go too much into it, but these are pre-printed on it. So great information, even if an agent who has been in the business over 15 years. Yeah, absolutely, Penny. Yeah, I mean, all of this stuff, it just resonates. And sometimes, we forget we're in the trenches, and it only takes that one little thing to have that hiccup, right? Or a derailment or a detour. And now you're just like, oh gosh, how do I navigate this, right? Again, bring the broker, bring the risk management team involved. We're here to help. Pre-printed examples: failures to make agreed upon repairs, refuse to permit agreed upon inspections, allowing the buyer to move into the property prior to close of escrow, as we said, allowing the buyer to make any type of repairs, renovations prior to close of escrow. He was reading this in the future. He already knew. So absolutely. Screenshot of the letter here. And then any additional resources, quick guide acting against the advice of the broker, please return to the main page. And there's also even a video, and I'm not going to share it, but there's also in the California Association of Realtors, there's a video that you can watch, and it just kind of illustrates as well, the importance of not to be entangled in a mess. So I hope that kind of gives you a little bit of perspective and understanding. And again, feel free to, please reach out if you have any questions as well. We're here to help, we're here to navigate, and we are here to, help you with any of your questions. Any questions before we close off? No questions?
Hey, Simon,
Yes.
quick question for Steve. Is he going to be having another one of the reviewing contracts and paperwork sessions again?
Uh,
I don't know. That's a very good question. Steve is here. Let's ask him.
The answer is I probably will. I'm probably gonna have one more freebie class. Because I'm not sure if you're aware, I formed my company called Contract Matters. And I'm actually in the process now of also getting the course approved through CAR for 8 hours of continuing ed
Very cool.
hours. However, I'm not going to be teaching 8 hours for the freebie class. I'll probably just do another, 2 to 3 hour freebie class. And I'll probably do it the first week. I'm kind of thinking maybe the first week in December. So kind of watch the announcements out there.